Good morning. My name is Dorothy Anderson. I'm an assistant bar counsel representing bar counsel in this action. This case is before you on the reservation and report of the single justice on the issue of the appropriate sanction for an attorney who has negligently misused client retainer funds. So this case, of course, presents the same issue that you've just heard, except that it is not in
It has in addition, if you want to think of it as a separate issue, right, the fact of some of these monies were to pay costs and expenses.
That's right, although that's not specifically reported, that certainly is an issue in this case. If I could just briefly review the facts. The client engaged Mr. Pudlo to represent him back in 1997, two possible purposes. The first was to explore a malpractice action against the client's divorce lawyer. And the second issue was that there were some post-divorce motions for contempt and/or modification going on at the time. The client gave Mr. Pudlo a $10,000 retainer in January of 1997. In February of 1997, he gave him $2,000 more. There are no records that indicate what became of any of those funds. In October 1997, Mr. Pudlo asked the client for another $10,000, and the client duly sent it to him. Mr. Pudlo did deposit that check into his IOLTA account, but within a couple of weeks he had withdrawn $9,950 of the $10,000 in 4 checks which were made out to himself, all of which he had notated the name Barbudo, who was the client. When he took those funds out of the IOLTA account in October of 1997, he had not earned most of them, according to an invoice which he later, much later, sent to the client. At that time, he had earned maybe about $3,500. Then, in July of 1998, by a fax letter...
I thought it was about $4,820. Oh, no, that's later?
Was that, well, there might have been some amendments to that. In July of 1998, by a fax letter to a client, Mr. Pudlo asked him for another $7,350. And at that time, he told the client that he needed the money, quote, to pay experts that we have used for our side of the case. In fact, at that time, the case hadn't been filed. Mr. Pudlo hadn't used any money to pay any experts. He hadn't engaged any experts. And in the remainder of the case, which went on until 2004, Mr. Pudlo never paid any money to any expert. But the client duly sent Mr. Pudlo a check for $73.50, which Mr. Pudlo negotiated. There are no records whatsoever of what became of those funds, and Mr. Pudlo, through the time of the hearing, testified that he had no memory whatsoever of receiving that money or what he did with that money. But the hearing committee ultimately found that he had misused those funds and spent them for his own purposes.
I have a question that I just wasn't clear on. Was there deprivation here? I think the respondent says no, but you seem to say yes.
I don't think there's any question that there was deprivation, Your Honor. If you look at the hearing committee's report, paragraphs, I think 50 and 69, what they state is that at the time that the litigation ended in 2004, Mr. Pudlo had never returned any of the expense money to the client, and he had gotten from him retainer funds greater than he even claimed to have earned in his invoice. And none of those funds were ever returned to the client, but for a civil action that was brought by the successor counsel and which was settled in 2007 for $37,000. The respondent finally filed the malpractice case against the divorce lawyer in March of 1999. His handling of it from that time forward was described in the board opinion, as extraordinary passivity. Mr. Pudlo did not create a bill for the client at any time between 1997 and 2003. He didn't keep contemporaneous records of the client's payments. He didn't keep contemporaneous time records of his work, of the legal fees he had earned, or of any withdrawals that he made against the client's payments.
Now, does it matter that this occurred in 97 and 98, which is before the change in rule in 2004? I mean, the rules were not very well defined back in 97, 98.
Well, they were defined, Your Honor, in the sense that they were very clear that all funds given by a client to a lawyer to hold for any purposes were client trust funds. They were very clear that an attorney had an obligation to maintain complete records of his receipt, maintenance, holding and disposition of those funds.
Right, but it was only in 2004 that the rules, I guess, said you may not take it unless you give an itemized bill. That was in 2004, was it not?
Yes, 2004 changed the rule to say that, yeah, the lawyer had to specifically send the client an itemized bill before he could take the money. But the rule was always that the lawyer had to earn the funds before he could take the money.
Okay, so what would you say was the governing rule before the rule change in 2004?
Well,
That you could take it without having billed, as long as you did
yes,
earn it?
you had to earn the funds, but there was no requirement that you specifically send a client a bill before you move the money from your IOLTA account into your own personal account.
And do we have a finding here that Mr. Pudlo knew that he had not earned it, or is that
Yes,
why it's
there is.
referred to
Yes,
as
there
negligent?
is such a finding. I mean, I think the hearing committee found that. Well, the hearing committee found that he did made no attempt to even determine whether he had earned the $99.50 when he took it in October 1997. He didn't do any sort of, he had no records. He had no, certainly hadn't written a bill. He had made no attempt to really add up his hours and figure out how much he had earned. He simply just took them.
Is that why this is a case of negligent misuse as opposed to intentional misuse?
Well, it's a case of negligent misuse because Bar Counsel was unable to prove that the misuse was intentional. That was certainly a contested issue at the hearing.
What does intentional misuse mean vis-a-vis Justice Gantz's question? Do you have to know? Does Bar Counsel have to prove that the lawyer knew that he had not earned the money?
Yes, I would say the Bar Counsel has to prove in those cases that the lawyer knew he didn't have to earn the money. At least, I mean, in this case, it was a very, very close call where the hearing committee basically said that, but for I think their words were a back of an envelope calculation, that he had made no attempt whatsoever to determine how much of the funds that he had received from the client he had earned.
Am I correct in my understanding that counsel received $2,000 from the client in February 2007?
No,
97.
1997.
Okay, so that was a typo, I think.
Yes, if
There
that's
was
what it says.
$10,000 in January of 97.
Another 2,000 in February for 12, and then another 10 in October for 22,000.
Okay.
And then
And
another
then the
73.50.
$73.50 for expenses in July, for a total of $29.50. And that was before, of course, the attorney had even filed the case. All he had done at that point was to send a 93A letter. In the fall of 2003, the client finally contacted another attorney, Donald Goodrich of Greenfield, because he was concerned about what was going on with the case. And he was concerned because, A, he didn't see much indication that the case was really moving forward.
Well,
B,
those aren't findings of the hearing committee.
well, yes, there is a footnote.
They say that he contacted them, and then Goodrich settled it.
Well, I think it also says that one of the reasons he contacted him was because Mr. Pudlo was asking for more money. And I did check that just last night, and there was a footnote to that effect.
So going back to the earlier point, am I correct that before 12/31/97, while this money was viewed as trust funds, there was no obligation under the rules to keep it in IOLTA account as opposed to a business account?
No, there was certainly an obligation to keep an IOLTA account. The only thing that changed was two things changed in 2004. which was that you had the obligation to send the bill before you took out any money, and you had the obligation of all these record-keeping requirements associated with an IOLTA account.
Okay,
All the
but the
reconciliation.
rules that I saw before that simply said you must keep a complete record of the trust funds. Is this then by rule, or is this by the interpretation of what that means, that you say that was in place?
Justice Gantz, I'm not entirely sure the rule that you were referring to.
Well, in 1981,
Well-
9-102 was promulgated, and in 9-102A said that all funds of clients paid to a lawyer or law firm other than advances for cost and expense shall be deposited in one or more identifiable bank accounts maintained in the state in which the law office is situated, and no funds belonging to the lawyer or law firm shall be deposited therein except as follows.
Right, they had to be segregated in special accounts.
And then in 1997, it was changed, and
Well, I think it was January 1st, 1998 that was effective, yeah.
well, yeah, it was effective in 1998. It was changed, but the basic change was one that said that the funds instead of may be withdrawn from that account as they're earned. It said they must be withdrawn at the earliest reasonable time after that portion becomes fixed, presumably to deal with the commingling, the potential commingling issue that was lurking.
Yes,
And IALTA was first mentioned in 1998.
yes, the requirement was always that they be kept in separate accounts from the lawyer's other money, that they be held in client trust accounts. The client trust accounts at that point didn't have to be IOLTA accounts, but in effect it was the same thing, except that the interest accrued to the benefit of the client as opposed to the benefit of the IOLTA fund. But there was no question that under the old canons and under the rules as amended on July 1st, well, the rules that went into effect on January 1st, 1998, that retainers were client funds that had to be segregated. And if you look at some of the materials that I have attached to the brief in the appendix, there are rulings from the Mass Bar Association, there's advice from MCLE, advice from other treatises, all of which very clearly advising attorneys that retainer funds were client funds that had to be held separately in client trust fund accounts until earned, and that not doing that would be a violation of the rules. I don't think there was no ambiguity about that in 1997 or 1998. The hearing committee and the board concluded that the respondent had negligently misused thousands of dollars of the client's funds, both as expense funds and retainer funds, that he'd failed to keep the required records of the retainer funds, that he engaged in dishonesty, deceit, fraud, and misrepresentation, and presenting in writing to the client that he needed $73.50 for expenses that had already been paid to experts, and also found that he charged a clearly excessive fee when he sent the client a bill in 2003 for an additional $9,000, not acknowledging $15,000 of the retainer funds that he had received. The hearing committee and the board also found that the respondent had failed to diligently represent the client, the board again characterizing his representation as extraordinary passivity. And the board also found that through 2007, the respondent was still failing to maintain required records of his client trust account. As Mr. Warner has already just gone over all the reasons why it does not make sense to distinguish in the case of intentional misuse between advanced fees and other kinds of client funds. In this case, we also have the issue of the advance costs. And our point there is that this is really a privilege given to attorneys, that they have been allowed to keep their expenses paid by the client in the business account, or before 1998, it didn't specifically say that, it would be highly ironic to say, well, not only do you have the privilege of not keeping it in your IOLTA account, but it's also not that bad if you take the money, don't use any of it for expenses, lose track of it, and tell the client that you don't remember ever getting it. That clearly is, it's just plain old stealing to do that.
After all of that, you recommended 1 year and a day suspension?
Well, Your Honor, based upon, the precedent of the many negligent misuse cases that have been handled and decided by the board, Justice Cowan's decision in the matter of Walker case, in which she basically gave Mr. Walker 6 months, explaining there that it was a single instance of commingling resulting in a single instance of negligent misuse with absolutely no other misconduct. We extrapolate from there that in this case, where you have a lot of other misconduct, where you have several instances of misuse.
I'm questioning
that's too small?
After all of this, you said, and that's should be 1 year and a day versus 6 months.
Well, we are again basing it on precedent, but I think what we say is that it should be at least 1 year and a day, Your Honor.
Just let me ask you one other question
Yeah.
about that. Does the chauffeur and 3 lawyers case focus on the intentional misuse?
Yes, those cases don't say anything about negligent misuse, and there haven't been any decisions of the full court about negligent misuse. So when we talk about that, we're purely basing it on precedent of the board and the one case by the single justice. But again, it was the board who said that for the same reasons they didn't want to give the full chauffeur penalties to Ms. Sharif, that we're also going to sort of lower the penalties for Mr. Pudlo, because this was not misuse, negligent misuse, albeit of classic client funds. It was negligent misuse of retainer funds and litigation expenses.
Thank you.
Thank you.
Members of the court, good morning. My name is William Pudlo, and I'm here representing myself in connection with this matter. I think that it's important to recognize just a few points. Personally, this has been a very humbling experience for me. As a member of the bar for over 37 years, when your peers suggest that your work is not up to snuff, it brings you down to a level where you really have to face the realities. When Bar Council first brought this matter in 2005, I had taken some steps at that time to correct my bookkeeping based on what I was told. Supplied those papers to Bar Council, and in September of 2009, when this matter was decided by the hearing committee, that was a tremendous message to me that it still wasn't up to snuff. And as I said to the board in arguing before the full Board of Bar Overseers, I've even gone further. I've tried to distance myself from the bookkeeping by even engaging a CPA to oversee it, even before they recommended that there be some monitoring. I recognize this is a severe deficit area, and I've been dealing with it since, notwithstanding those issues. What I would suggest to the court is that one important matter to look at in connection with this case is what went on between myself and my client. Repeatedly during the hearing committee and even before the BBO, I emphasized without question that Mr. Barbuto and I came to an agreement tacitly that there would be no accounting until after the resolution of the malpractice case. Now, Bar Council suggests nowhere that this was a reality. I mean, I've argued this 3 times now, that there was an agreement.
But that would, I mean, there may be an agreement that there would be no formal accounting, but in order to make a formal accounting at the time that you had agreed you would, you need to know what you're doing as you go along.
Precisely, and I did keep notes, and that's why in 2003, when Mr. Goodrich, in behalf of Mr. Barbuto, contacted my office and said, my client, he didn't say client, I take that back. He said, Mr. Barbuto has asked me to obtain from you an accounting. And so we were in the midst of litigation. I prepared the best accounting I could at the time from all the records I could glean in my office. And it was not as good as it should have been because my records weren't that good at that time. I admitted that before the committee and to bar counsel. Nevertheless, the thing that has always puzzled me in this case is that I was never, although there were suggestions that my handling of the case was extremely passive, the circumstances from the record indicate very clearly that there were many complications involved in this case. It wasn't a straightforward, go by the time standards type of case that you deal with. There were situations where Mr. Barbuto brought the claim, and somewhere down the road, within a year or two, the defendant brought in his accountant, Mr. Barbuto's accountant, as a third-party defendant. And he was ill with cancer, and the discovery process involving his depositions, which covered several sessions, took days and days. In fact, it took months because he was ill with cancer. Ultimately, he filed a bankruptcy, which then caused the case to be stayed in the Superior Court, and there was some discussion as to whether or not the court had, in fact, caused the delay by losing track of the file. In that meantime, I was working with opposing counsel to resolve some of the discovery issues. In fact, in my brief, I suggest that there was a difference between what I view the facts are and one of the conclusions drawn by the BBO. They asserted somewhere along the line that nothing was done regarding expert witnesses, but the testimony at the hearing committee and the facts of some of the exhibits indicate that for over 2 years there was work being done, A, with experts, and B, in order to obtain the deposition of the defendant in the case. It was not something that came up at the last minute. It was something that had been in process for over a year. There were several faxes and letters exchanged between myself and opposing counsel that indicated to the committee that there was, in fact, some effort to take this deposition. It didn't occur at the time of settlement, which brings me to another point, which is very unusual and something I'd never experienced in my entire practice, where while I am representing a client, unknown to me, another attorney is settling the case with opposing counsel without my knowledge. I was shocked in May of 2004 when I walked into a session at the defense counsel's office to conclude a deposition and was told at that time the case is settled. Quite shocking. I had never had that happen to me before.
Mr. Pudlo, what, God forbid, what if you had been killed in an automobile accident while this case was progressing and the money had been drawn out and you had applied it for your own personal use, intending to do the work in the case but not having completed a significant part of the work in the case? How would the client get the money, get his money back?
Well, I would assume that there would be a claim against the estate.
But why should the client have to go through that?
I can't answer that question because it's highly speculative.
But isn't that the point of the rule?
I believe the rule is to protect the client's interests. I don't disagree with that at all. In this particular case, there was no, contrary to anybody's suggestion, there was nothing done. Mr. Barbuto wasn't asked for money or billed anything from 1998 to the time of the settlement of the case in 2004. There were no discussions. There was no, my testimony was there were no billings, no requests for funds for a period of 8 years. And the reality is, in that period of time, I was earning and had earned the funds. Notwithstanding, bar counsel would argue that there was deprivation. I would suggest there wasn't any because, as I suggested to the hearing committee and to Bar Counsel. Concurrent with the complaint, there was also a civil action brought against me, not for malpractice, and that was the other surprising thing. It was just a complaint. Ultimately was settled, and Mr. Barbuto was given far in excess of what he asserted were any fees in settlement of that case. So there was no deprivation. He was well paid. And that was testified to at both the hearing committee and the BBO hearing as well. The argument that I would suggest in this case is very similar to what you heard in the prior cases as well, namely that what Bar Counsel is trying to do is homogenize the process to a point where there are no distinctions. This court, for years and years, has made it clear that every case, as Mr. Burson suggested to you, sui generis, has its own nuances, its own individual aspects, its own individual factual situations. And that's what the hearing committee took into effect. They looked at the entirety of the whole process, the entirety of the whole representation, the entirety of the entire matter with Mr. Barbuto, and they concluded what they did. Bar Counsel, again, said, no, it's disparative with others, and we went before the full board. And even though the board enlarged the sanction somewhat, basically, they still found nothing different in the basic elements than the hearing committee. And so Bar Counsel, again, with her diligence, sought to increase the sanction again and brought it before the single justice who reported it to this court. I think there's also room in connection with the cases that this court has dealt with in the past where this court has recognized that in cases where an attorney is disciplined, and I know in my personal case, I have experienced, first, humility, as I said earlier. Secondly, the recognition of my deficit area. Thirdly, the fact that there has been a financial, professional, spiritual, and personal consequence to all of this. It's a tremendous strain, and I'm not saying that I'm unique in this. Anybody who goes through this process is under horrific strain, especially when you're a sole practitioner. As I said in my brief, there's many situations where I've lost my ability to be an expert witness in cases because I'm tainted now. I have the stigma of this disciplinary action. The minute it went up on the BBO website, I had comments from many of my peers in the community. As I've suggested to both to the hearing committee and to the board, I try, even as a solo practitioner, to work with my peers. I write, I teach. I've conducted seminars for many young lawyers. I've mentored. I've written for MCLE. I work in my church. I'm not trying to excuse my deficit area. I'm just simply saying I have a worth too. And what I'm suggesting to this court is that I have experienced some of the impact of a sanction for the past 5 years. I've experienced what it is to be looked at differently by my peers, to be treated differently by my peers. And believe me, when I tell you with all honesty that it has an impact on me as a professional, what I've done to my profession. When I'm cited for misconduct of any kind, that reflects on my profession, and that hurts me. Basically, what I'm asking the court to do is to look at the totality of the circumstances, to look at the fact that there was distinction drawn between negligent and intentional, that there were nuances to this case that weren't simply nuances that came out of the air. They are very unique to each case, and I'm urging this court to continue to recognize these distinctions. As I mentioned earlier, you would give a homogenization to the process of sanctions, and as Mr. Burson suggested earlier, Bar Counsel would have the leg up. the discretionary ability of a hearing committee would be torn apart. The BBO would lose its discretionary authority.
What is the consequence here, given the BBO's position? I mean, they're not saying that it's presumptively disbarment or indefinite suspension. They're saying 6 months more than what the board proposed here.
And they suspended it, right?
They recommended a year,
Oh,
6 months suspended. That is correct.
Mark,
Right, they went 1 year and a day, and the board says 1 year, 6 months to be stayed.
Correct. To be candid, Your Honor, I'm going to be 65 years old. I don't have many options out to support my wife and my family. And my desire is to be able to resume my practice under some guidelines, as I've even imposed on myself. I mean, I have a CPA in place. I have a paralegal doing the reconciliations. When I tell this court, as I told the board, I want to distance myself so that I'm not going to have the problem in the future going forward. That's my goal. And that's my position. Thank you.
Thank you.
All right.